Welcome, everyone, to the annual William P. Murphy Lecture at the UNC School of Law. I'm Martin Brinkley, the Dean of the Law School, and I have the honor of both recognizing the person for whom this lecture is named and welcoming our guest speaker. The Murphy Lecture Series was established by the class of 1990 to honor Henry Brandes Distinguished Professor of Law William Patrick Murphy, who was a member of our faculty from 1971 to 1990. Each year we bring to Chapel Hill public intellectuals, noted lawyers, and national political figures from the fields in which Bill Murphy worked, taught, and wrote: labor law, employment discrimination, and constitutional law, to share insights on the contemporary practice of law or a cutting-edge legal issue in one of these areas. We're immensely proud of what the lecture series represents and of who Professor Murphy was, and I'm glad that you've all chosen to be here. Bill Murphy was a champion of the American Civil Rights Movement during a time when racial tensions were at their height, particularly in the Deep South. As a native-born Southerner and a young graduate of the University of Virginia Law School with a graduate law degree from Yale, Bill came to Oxford, Mississippi in 1953 to serve on the faculty of the University of Mississippi School of Law. He spoke out early and forcefully in the wake of the Supreme Court's 1954 decision in Brown versus the Board of Education, bravely teaching what the Constitution and our national commitment to equal protection under the law required all to do. When he was accused of atheism, communism, integration, and subversion, he responded, "I will not tailor my teachings to satisfy any cult of crackpots, fanatics, and willful ignoramuses." His convictions did not go unnoticed by the University of Mississippi's administration, the Mississippi State Legislature, and other opponents of equal rights in the American South. State and university leaders called repeatedly for Bill's termination, and he was eventually forced to resign in 1962, despite the efforts of 121 of the law school's 182 students, who signed a petition expressing their complete faith, trust, and absolute confidence in the teaching ability and integrity of Bill Murphy. Their efforts were unavailing, at least in the short run. Bill later returned to Oxford to a hero's welcome, but only after the passage of many years. Bill Murphy moved on to the University of Missouri School of Law, only to find himself again in hot water when he spoke out against what he viewed as the unconstitutional exercise of executive power by President Lyndon Johnson, who was moving the nation towards a major war in Vietnam. Bill deeply valued academic freedom, faculty governance, and the ability to freely voice one's convictions. He eventually found at UNC a port in the storm. He arrived in 1971 at a place that his wife, Joy, so wanted him to find, a place that would keep him even when they disagreed with him. It was a place where he remained a welcome colleague for the next 36 years until his death in 2007. Bill Murphy's life work was dedicated to advancing race relations and to preparing the next generation of lawyers to tackle the most challenging legal issues of the day. Many of his former students regard Bill Murphy as one of the faculty members whom they remember as most influential in their own lives and careers. The Murphy Lecture has brought to Carolina law many distinguished guests, including our own Julius Chambers, the late U.S. Attorney General Janet Reno, Congressman John Lewis, W.J. Bill Ussery, Jr., the former U.S. Secretary of Labor and mediator for the 1994 baseball strike, Elaine Jones, former Director Counsel of the NAACP Legal Defense and Educational Fund, Seth Waxman, former Solicitor General of the United States, Judge Rena Raggi of the U.S. Court of Appeals for the Second Circuit, and last year, Harvard Law School professor Cass Sunstein. It is our great privilege to have with us today the interim chancellor of the University of North Carolina at Chapel Hill, Kevin Guskowitz. Chancellor Guskowitz, we are most honored to have you join the law school community for this central annual event in our intellectual life, and thank you for being here. This year's Murphy lecturer, Tom Goldstein, has deep ties to us here in Chapel Hill. He is a 1992 graduate of the university's College of Arts and Sciences. Tom is well known as one of the nation's most experienced Supreme Court practitioners. He has served as counsel to a party in well over 100 merits cases at the court, personally arguing 42 of those cases. Only 3 lawyers in the court's modern history have argued more cases in private practice. He has been counsel on more successful petitions for certiorari, which for the non-lawyers among us is just the way you ask the Supreme Court justices to agree to hear your case, over the past decade than any other lawyer in private practice. Over the past 15 years, his law firm's petitions for certiorari have been granted at a higher rate than those of any other private law firm. Perhaps more than any other advocate in practice, Tom represents the complete spectrum of litigants before the court. His work is not associated with any particular perspective or ideology. For example, Tom has prevailed on behalf of bond purchasers, corporate civil defendants, corporate civil plaintiffs, debtors, employees, immigrants, investors, individual civil and criminal defendants, local governments, and persons with disabilities. In addition to practicing law, Tom has taught Supreme Court litigation at Harvard Law School since 2004 and previously taught the same subject at Stanford Law School for nearly a decade. He is famous as the co-founder and publisher of SCOTUSblog, a website devoted to comprehensive coverage of the court, which is the only web blog ever to receive the Peabody Award. Tom has received a variety of recognitions for his practice before the Supreme Court and for his appellate advocacy. In 2010, the National Law Journal named him one of the nation's 40 most influential lawyers of the decade. The same publication included him in both of its most recent lists of the nation's 100 most influential attorneys. Legal Times named him one of the 90 greatest Washington lawyers of the last 30 years. And GQ named him as one of the 50 most powerful people in Washington. Tom Goldstein, welcome.
To the Dean and especially to the Chancellor as well. It's so nice of you all to take the time. It's an incredible honor to get to come and talk with you and give you my thoughts on what I think is really going to be the major issue related to the Supreme Court in the upcoming election. It's humbling to get to give the Murphy Lecture. When I was on campus, he was a giant in the law generally and here at the law school. I spent a lot of time here at the law school. It's nice to be able to evolve the Murphy Lecture from, a tradition where you have had unbelievable, scholars, people involved in politics who played fundamental roles in incredible social issues, and now the guy with the blog. It really diversifies things into the modern era. And it is also humbling when you think about people like Julius Chambers, who I had the great privilege of working for, and kind of grew up when I was at the law school working for the law firm that he founded. When you think about other people who were the head of the Inc. Fund, the LDF, and then the flip side of being told that I am not affiliated with any particular ideology is to say that I'm the hired gun. It's really, I kind of pale in comparison to those folks who are true heroes. Whatever you believe about the law, that the folks who made such an incredible difference are really what we should all aspire to be in the law. So I thought that I would talk with you about what has been referred to for nearly a century now as court packing. Because I do think that as we go into the election in 2020, it is going to be what most of us are hearing about, and it's going to be an incredibly important issue for Democratic political candidates and how the president responds and uses the Supreme Court as a tool in the re-election campaign. And it's a neat thing to be able to talk about today because it has such a historical footing. And it's a little bit misunderstood, and it's interesting to think about what its justifications are, what its constitutional foundations are, and what its political implications are. And it is really the story, ultimately, of 4 Supreme Court justices and 2 presidents to think about that question in the context of American politics and the tradition of the Supreme Court. So if you think about the Supreme Court and why you might change the composition of the court when it comes to the number of seats, which is ultimately what court packing is about, you might be thinking about a few different problems. One of the problems that you might be thinking about is the age of the justices, and this is actually the story of Bill O. Douglas. So the Supreme Court justices, at least going into about 5 years ago, had an average age of roughly 116. The court had grown older and wiser, it's my obligation to say as someone who advocates before, over time. And when Article 3 of the Constitution was written, people just didn't live as long. The life expectancy of someone in the United States back at around 1800 was much closer to 40 than it was to 80. And Supreme Court justices get unbelievable health care, and that's how we've had the great good fortune for Justice Ginsburg's cancer to be discovered. It's really because she goes to Walter Reed like they do, and they found her in the course of examinations, and when she happened to have the good luck of breaking ribs and was examined, and the justices just live much, much, much longer now. They used to be appointed even younger than they are now, and they wouldn't last into their 80s and sometimes 90s. And so there is a sense that, well, maybe the justices get too old and become kind of mentally infirm and not up to the job. And we have been unbelievably lucky as a country for the past century or so that this has not been a real problem. And I am just obligated now to reassure you that all 9 of them are functioning at the absolute highest level possible. They also are super funny. They smell great. I cannot say enough good things about your justices. But there was a time when it was less certain that that was true. And so Bill Douglas, who was derisively I won't even say what his law clerk called him, but he was not regarded as a lovely man, particularly towards the end of his time in the court. But in 1973, he had become kind of more and more fixed in his ways, a little bit more irascible. So, for example, he one time during the court's recess was back on his mountain home, and the ACLU asked to enjoin bombing in Cambodia. And he decided on his own to grant an injunction against the United States bombing Cambodia. It was one of the rare modern instances in which a party affirmatively ignored an order of the Supreme Court. The United States military ignored it, and it was overturned by the full court 6 hours later. But that was the kind of thing that Bill O. Douglas was into, and in 1973, he did have a stroke, and it really was quite debilitating for him. And so he nonetheless did not retire, and the court continued on with him as a member going into 1974. And by the November of 1974, Abe Fortas convinced Bill Douglas to retire from the Supreme Court with some pressure, and the court itself had voted that if there was a case in which his was the dispositive vote, they would ignore it, and they would rehear the case when eventually he left the court, because they all knew that it was inevitable. So Bill Douglas kind of succumbed to pressure and retired, or so everyone thought, because Bill Douglas also decided that he could take senior status, and that meant he could continue to participate in the cases. So when the death penalty, for example, came back to the Supreme Court in the following term, he attempted to sit on the case and attempted to vote, and the court wrote him a letter signed by all the members of the court saying, you know, you really have, when you retired, we all had a party. It was great, but we thought that you might stop by, but we were not convinced that you would attempt to continue to participate in the cases. This is a junior varsity, or the junior varsity version of that story is the great Whizzer White. When he left the court, did not attempt to continue to sit on cases, but there was an oral argument during the period of his retirement. This may be apocryphal, but we treat the story as true because it's so good, where they were arguing in the court, and there was this banging, and this banging, and this banging, and people couldn't figure out what it was. And a set of notes went back and forth. Justice O'Connor wrote a note, and then a note came back. And the note said, "Dear Whizzer, during oral arguments, we would appreciate it if you would stop playing basketball." And the note back said, "Dear Sandra, I don't work for you." But Bill O. Douglas's problem was more serious, and he was eventually convinced that he was no longer a member of the Supreme Court. But there aren't a lot of things that you can do. You know, if anyone in law school ever asks you the question, can a Supreme Court justice do X? The answer is always yes, because they can do whatever it is that they like. And of course, Article 3 of the Constitution says that they will hold their positions in times of good behavior. And it is super duper hard to impeach a Supreme Court justice. So there just haven't been that many modern instances. There are instances in the 1800s where the history reflects that, you know, for maybe half of somebody's term at the Supreme Court a couple of times, the person was mentally infirm. But we've become so good at kind of vetting candidates for the Supreme Court, and now we get closer and closer back to putting them on basically straight out of high school, that you don't really have the problem of somebody being put on the Supreme Court when they're 50 or 60 or 65 or something like that. Now, there may well come a time when there's a crisis, but so far we don't have a real problem with age, and that's not a reason I think that you would seriously change the composition of the Supreme Court. You might decide to change the composition of the Supreme Court because of just straight ideology. You think the court's gotten too conservative. And that's the view of some. That's not really fair play, probably, as a constitutional matter, because the Constitution is structured so that the court can, on some level, follow the election returns, because the president gets to nominate a Supreme Court justice, or at least we thought before Merrick Garland that they did, and the Senate shall consent. And that means that you get, as you have a more conservative country and a more conservative president or a more liberal one, then they will, depending on the accidents of timing of when there are seats in the Supreme Court, the court will move in that direction. And however conservative the Supreme Court is right now, and it is very conservative, it hasn't been this conservative in at least 90 years, it is not as conservative as it could be. Ask any conservative, because they are very frustrated with things like Roe and other lines of cases. There are many people, judicial conservatives, who are committed to the Supreme Court and the issues that come before it, that believe that under Sandra Day O'Connor and Justice Kennedy's decisive fifth vote, the court was far too liberal, and there's a lot of work still to be done. Ask any progressive or liberal, and they will think you are smoking crack. That the court has gone way, way, way to the right, but all things in life and law are relative, and the court is now, certainly the data would show, and any objective observer would say, much more conservative than it was 30 years ago. But there is still a conservative project to move the court to the right, and that is as it should be under our legal system. And if Democrats can win the presidency and the control of the Senate, well, then the court will move back to the left. So I wouldn't say as a normative matter, in terms of what's right and wrong, that you would change the Supreme Court's composition because of ideology. If you disagree with it, well, then go in elections or win the intellectual battle. Increasingly, conservatives have been winning the intellectual battle in academia and in the courts, and the law has turned in that direction. And if that's not right, turn it back around. Now, the third reason that you might change the number of seats at the Supreme Court is that you think a seat was stolen. This is true on some level, and that is the late, great Justice Scalia passed away when President Obama was president, and President Obama nominated someone for the seat. And Mitch McConnell, in what was one of the, a historically strong and successful political move, said almost immediately, we are not going to hold hearings for this nominee because it's an election year, and we are going to allow the people to decide who it is that should be the president in 2016, and as a result, we will find out who it is should be a Supreme Court justice. Now, Republicans at the time said that this was a historically sound view of things. That was not true. As Michael Gerhardt and other people have detailed, it is not the case that we had not had nominations and confirmation hearings for Supreme Court justices in the 4th year of a presidency or the 8th year of a presidency, going all the way back to Washington. It had been uniformly the case that presidents, when there was a vacancy in that year, would nominate someone, and that the Senate would act on the nomination. It is simply historically inaccurate to say that the process would stop and that the Constitution says the president shall nominate and the Senate shall confirm in the first 3 years of a term, or anything like it. It had never been understood that way. Nonetheless, the Constitution doesn't say what it means for there to be a process of nomination and consent by the Senate. And arguably, you could say, well, that means that the Senate, if it is in control of one party, is entitled not to vote at all, because they just don't consent. And if there's going to be a consequence from that, then that will be a political consequence, and you will hold them accountable. And that is probably the right answer. It is, as a historical, as kind of a sub-constitutional practice, been true that if you put a nominee forward, you would have hearings and you would consent or not. And you say, well, what's the big deal? If Republicans could have just said, we're not going to vote the person out of committee, why is it that they have to hold a hearing at all? The reality is that Mitch McConnell knew something, and that is if Merrick Garland, who was the president's nominee, of course, had been given a hearing, he would have been confirmed because there were members of the Republican Party, people like Susan Collins, who would have been perfectly satisfied with a Merrick Garland and would have allowed him to get onto to the Supreme Court. It wouldn't have been an overwhelming confirmation vote, but Merrick Garland would have been confirmed. And so it's consequential, your view of whether there's an obligation to hold a hearing at all. Or put them to or simply to say that the Senate won't act on it at all. So you could say there is a decent view, I think a stronger view than concerns about age, than concerns about ideology, that the left in the country has a reason to say that there is a seat that has been mistreated as at least as a norm in terms of who should be on the Supreme Court. So maybe you would do something about the composition of the court. All right, so if you're going to do something about the composition of the court, you think, what are my alternatives? So there have been three that have been put forward. So the three are, there are lots of them, but the three principal ones right now are, we would have Supreme Court justices of an 18-year term. Now, the idea here is that if you cycle justices on and off with some regularity, you will have less pressure to put somebody on who's very, very young and who will serve for 40 years or something like that. And it'll just become depoliticized because it is just a more natural evolution where you're less likely to just try and seize and hold on to the seats. The difficulty is that it's unconstitutional. So the Constitution said, and sometimes that's a problem. So the Constitution says the president's going to nominate, the Senate's going to confirm, and the person will serve during times of good behavior. There isn't a time limit. And you really can't, I think, say, well, look, I'm not saying after 18 years that they're off the Supreme Court, they just take senior status, because the Bill O. Douglas experience shows that's not a thing. You don't get to just say to someone, you're senior status, you're a Supreme Court justice, you just can't sit on and decide the cases. And a similar problem, constitutional infirmity comes, I think, with the second proposal, which is we would have 5 members of the Supreme Court who would be nominated by, put on and selected by Democrats, and 5 by Republicans, and then 5 would be picked by the 10 justices. It doesn't work that way. The Constitution says the president, whoever the president is going to be the person who nominates the justice. So if you can amend the Constitution, well, congratulations, because I have some things I'd like you to do, but in general, it's not easily done, and we've kind of gotten out of the business of amending the Constitution. So I don't think those two things work. But weirdly, court packing is completely constitutional and has a real historical foundation, in fact. When I was starting in law school, thought that the Constitution must say that there are 9 justices. That's totally wrong, as basically everybody other than me knows that it's by statute. So in 1789, the Congress passed the first Judiciary Act, and it said that there shall be 6 justices. Now, nobody was thinking about ties. I don't really understand what was going through their head, but we started out with 6 justices. And then Jefferson became president, and he had political opponents in the Congress, and just as he was going to come in, they said, we actually don't, there was a retirement, we don't want Jefferson to be able to put on the 6th justice, and as a political move, Congress reduced it to 5. So there was a period in the country's history when we had only 5 justices in the court. Then Jefferson's party, they got more power in Congress, and it became 6 again, and then to give him more power, 7. So we've actually gone through at the very, very early in the country's history a period where for political reasons we maneuvered around and changed the number of justices. Then it happened again. It happened with Andrew Johnson. So Andrew Johnson becomes president. By then we had 10, again, very into ties. What had happened is that there was much more of a tradition at the time that the justices rode circuit. So a justice literally would get on a horse and go off to some other part of the country and would hear cases in their capacity as a circuit justice. And by the time Andrew Johnson became president, we had 10 circuits, and there had become 10 different Supreme Court seats. The Congress, and particularly the Senate, hated Andrew Johnson. That was the one thing they could agree on. They had huge problems with Andrew Johnson's appointments practices, and there was an impeachment about this, an impeachment effort, and there's a whole historical record of it. And what the Congress did is that got rid of the 10th seat and the 9th seat, and it was headed all the way down. It got down to 7. So we got down to 7, and then after Andrew Johnson left, we went back to 8, and then we went back to 9. And so we have been at 9 since 1867. And we stayed there pretty comfortably. But that cycle did happen, both with respect to Jefferson and Johnson. We went down for a political reason, and then we went back up as soon as the political winds changed again. It's been relatively calm other than that. We, of course, come to the big example that everybody thinks about, and it's where the whole practice got its name, and that is FDR and court packing in the 1930s. So this is a situation where rather than just trying to prevent the president from being able to nominate someone, where so kind of it's a reduction controlled by the Congress, you have now the president trying to increase the number of seats in order to overturn a body of precedents. So we had the Great Depression, the president enacts the New Deal, and he creates his own problem in a very strange way. There's a justice on the Supreme Court named Justice Vandiverter. And he is one of what's known as the four horsemen of the apocalypse, or the four horsemen, as we would call them when it came to the Supreme Court. And what had happened was that he was a very conservative guy, didn't really believe in broad congressional powers. The Supreme Court itself was a quite conservative institution at the time. And he was getting older and getting ready to retire. But in the big New Deal package of programs, one of the things that when we were spending a lot of money on public works projects and the like, one of the things that happened was that Congress, in order to save some money and to poke the Supreme Court in the eye, reduced the pension of Supreme Court justices from $20,000 to $10,000. And the two of the justices, including particularly Vandiverter at the time, responded by saying, okay, I'm not leaving. And this actually, FDR's New Deal proposals and the legislation and the budgeting then created a problem by keeping Vandiverter on the court. And what happened is in the 1930s, the Supreme Court started striking down central features of the New Deal. And there were some very significant cases like Schechter-Pulte and the like that were decided in this era where the president lost some control of the ability to remove federal officials, and the Supreme Court started taking quite a narrow view of the commerce power of the Congress. And the commerce power is kind of the foundations for basically everything that Congress does, because it's viewed as implicating interstate commerce. And so the Congress was spending a lot of money, and the Supreme Court was really pushing back on this. So FDR gets very frustrated that the New Deal is being struck down, and FDR has just been elected, has enormous momentum. He gets elected by a wide majority, he has a wide congressional majority, and he says, what I'm going to do is, it's not that I'm trying to pack the court, it's just that I think that the court is really getting behind on its work. At the time, the gap between cert being read in a case and oral argument was 4 weeks. So this did not really hold up as a huge argument. And so he said, however, for every justice who is over 70 years old who doesn't retire, I want to put on a new justice up to 6 justices. So it was pretty darn dramatic. They were going to go from 9 to 15 very quickly. And so FDR had one of his fireside chats and proposed this as a method of just bringing the Supreme Court up to speed in the modern era, and it landed like a lead balloon. And both within his party and across the Congress, it got very little support because it was so evidently an effort to take a nonpartisan, what was perceived as a non-political institution, just react to a specific line of cases in order to enact the president's own agenda. And the head of the Senate Judiciary Committee refused to allow even hearings to be held on it for a long time. Eventually it was held up for so long that its main Senate sponsor died. And it eventually was rejected 10-8 in committee, even though the president, FDR's party, still had a significant majority in the Congress. And this was kind of the death of every effort since then to engage in court packing and to change the composition of the Supreme Court. So then you think, all right, it's constitutional. We do have a tradition of actually doing it for the reason that politically, the Supreme Court, either we don't like the president or we don't like what the justices are doing, so we're going to manipulate the number of seats in the Congress. And you say, all right, well, if it's constitutional to do, and it's consistent with a kind of a sub-constitutional norm, that is, it's not against the rules and against the traditions, what do you actually think of doing it? Well, if you could do it, The question is, what would come of it? Because the real problem with a plan like this is it doesn't have a natural stopping point. And you see that in the first two cycles, where we went down, and then we went back up, we went down to 5, then we went to 7, we were at 9, we went down to 7, and then we went up to 10. And eventually, by the way, obviously after what happened is they brought it back to 9 so that we would have an equal number of, we wouldn't have ties. But there's no logical stopping point. And I think it is perfectly fair to say that if you were to adopt a plan that says we are going to increase the number of seats, you're going to get into a tit for tat when you do have politics get kind of out of line of divided government, because this does require whatever political party wants to do it to control not just the presidency, but also, of course, the Senate and the House, and you're going to have to get rid of the filibuster in the Senate unless you have a very, very wide Senate majority. And so one problem is that if you are trying to do it for instrumental reasons, and that is, for example, you're trying to respond to what happened with Merrick Garland, then you are not actually probably going to be able to accomplish something over the long, long, long term. But for Democrats who are thinking about doing this, I think the problem is much larger than that. And you just have to step outside of the law and think about politics right now. It is the case in American law that conservatives care more about the judiciary. Now, there are exceptions that prove every rule, but judicial conservatives have been running against the Supreme Court for full-on 40 or 50 years now. They reacted to cases like Roe, including they also reacted to particularly President Nixon and cases involving police powers. Some of it was a reaction to the civil rights era and the Supreme Court's activism in that period. But conservatives have looked at the Supreme Court and said, this is an anti-democratic institution. Maybe these things should be the law, but it's the job of legislatures, not the justices. Too much stuff is being made up by the court in their minds and being constitutionalized. And conservatives have therefore been very, very, very good, including because it's very easy, it's much easier to run against something than it is to run for something. And it is much easier to criticize the Supreme Court than to praise it, because this is how the law works. If the Supreme Court decides something and you agree with it, it's because it was obviously right all along and it's written into the law. If the Supreme Court does something and you disagree with it, it's because they're completely out of control. Activists implementing their own policy preferences. It's really that simple. And so if conservatives look at things that the Supreme Court is doing and disagree with it, as they have been able to do for several decades, and really kind of build up a sense of outrage about the Supreme Court, they can run against things because whatever the Supreme Court does that's right, it's not, they don't know credit to them. And so you do have kind of, in the political culture of the country, conservatives and the Republican Party are much more attentive to being able to rally around the Supreme Court. So weirdly right now, you have a situation in which progressive groups have decided to take seriously, in the wake of the Merrick Garland debacle, the idea of changing the number of seats in the Supreme Court. And they are not being shy about it. The leading organization is called Pack the Court. And so what you are really doing, I would say, if you are on the left and you are seriously talking about this right now, is you are giving President Trump the perhaps single thing that is most likely to get him reelected. Because there is a part of the American polity that is very, very, very committed to the Supreme Court and will hold its nose about whatever candidate in order to make sure that certain decisions of the court are overruled. And this is very much an issue for the pro-life community, right? Getting the Supreme Court is number one on their agenda and making sure that it doesn't turn to the left. And there's a significant argument that if it were not for the fact that Justice Scalia had passed away and the Supreme Court seat was open in 2016, that there would not have been nearly the motivation for a large community to come out and elect President Trump in the first place. So weirdly, if you are on the left and you are interested in this, the most important thing that you can do is not talk about it. Because Elizabeth Warren, for example, and so actually 3 of the major Democratic political candidates have come out in favor of this idea. But what is really going to happen is that President Trump is now going to have the opportunity to say, look at these people, they are trying to steal the Supreme Court. Because there's a level of satisfaction in the country. If you ask ordinary Americans, do they believe that the Merrick Garland seat was stolen? No, they don't in any way. They're not really aware of kind of the history of this. It was regarded as kind of ordinary politics, and they can't even name a member of the Supreme Court. So it's not like they're deeply, deeply engaged in this process. But if you can point to your opponent and say, they're trying to pack the court, it is a very easy bumper sticker message. And so you have a situation in which you are inviting, simply by making this a major issue in the democratic politics, you are inviting kind of the counter-revolution. And this is really what happens when it comes to things like primaries, and when you have the debate over who it is going to be the Democratic nominee, because we are in an era in which progressives are highly motivated against President Trump, and this can easily become a litmus test for whoever would be the candidate. What are you going to do about the Supreme Court? And we look for bumper sticker solutions. We look for very simple solutions. We look for very simple mottos. And that is why you see so many candidates on the left coming out in favor of this idea, and why it is going to be so easy for someone on the right to rally them. Now, to be honest, this is really the upshot of a failure by President Obama. As someone who was an admirer of the president was kind enough to write for SCOTUSblog about his nomination. But we are really dealing with, I think, fundamentally a political consequence, and we may completely change the norms about how we treat the Supreme Court as a result. What happened when Merrick Garland was nominated was President Obama being a bit of, and I say this kindly, a law professor. President Obama decided that what he was going to do was not try and move the court ideologically significantly. What he was going to do was he was going to pick someone who Republicans, in fairness, had said would be an ideal candidate that they had no objection to, and who kind of came from central casting as a Supreme Court justice. Merrick Garland, in his 50s, the chief judge of the DC Circuit, regarded by everybody as extremely centrist, about as conservative a Democratic nominee as you were ever going to see, votes for the government in all kinds of cases. And so what happened is that President Obama, when Justice Scalia passed away, picked somebody that he thought, okay, it's an election year, Republicans are going to kind of be resistant, this is somebody who I can get through. But what he didn't realize is that everybody at the time knew one thing for certain, absolutely for certain, and that was, of course, Hillary Clinton was going to win. Did you see the guy on the other side? There was no chance, if you just take ourselves back to 2015, 2016 in particular, what people thought was going to happen in the election, particularly on the left, they could not imagine that someone could lose to Donald Trump. And so interest groups on the left refused to rally behind Merrick Garland. And so what you had was this guy, perfectly acceptable to everybody, motivating to absolutely nobody. And what groups on the left decided to do, and Merrick Garland is, I am obligated to say, as someone who practices in the DC Circuit, an incredibly intelligent, but really is unbelievably respected, and is, if you objectively want just really smart people on the Supreme Court who aren't ideologues, you want a bunch of Merrick Garlands, it's true. But what happened is that groups on the left decided, what I'm going to do is I'm going to let Merrick Garland sit there. The Republicans won't vote for him? Fantastic, because when Hillary's elected, I'm going to persuade her to put on a progressive. And Democrats got stuck because President Trump was able to run on the basis of the Supreme Court and say to conservatives, to say to people who care a lot about religion in American life, who care a lot about pro-life issues, who care a lot about police-related issues, if you elect me, we're going to get that Scalia seat, and we are going to fill it, and you will cement a Supreme Court majority. But if you vote for the other person, you are going to lose the Supreme Court, because the Scalia seat was the one that would flip the court ideologically. But nobody was rallying behind Hillary Clinton on the basis of the Supreme Court, because who's going to get that excited about this guy? And so President Obama, I think, made a grave political miscalculation. But that's how I think the Supreme Court operates these days when it comes to politics. And that is, you have to think in very, very simplistic terms. So if you do want court packing, the most important thing you can do is not talk about it. And be also aware that what's good for the goose is good for the gander. I don't know if anybody noticed this who's really behind these proposals, but 2 of the 3, the presidency and the Senate, are controlled by Republicans. Kind of building this up right now is a really, really good thing. It may come back to bite you pretty quickly. But if you do want it and you think that the Democrats will win the presidency in 2020 and will win the House, just don't tell anybody about it. And then in 2021, start talking about it. But it is really interesting to have the opportunity to kind of talk about it as a kind of a question of legal discourse and what it is that we care about in the Supreme Court and what problems that we have and kind of where it fits in historically. So maybe I'll stop there. And then I think we hope to reserve the remainder of the time for questions.
complicated legal issues, at some point stop talking about the court as sort of just something that deals with the law and start talking about it in terms of politics? And I guess I was curious, could you give us a little bit more insight into when you're practicing in front of a court, how often you switch frames like that?
Well, so I'm a big legal realist. I'm a big believer that there's a difference between the reasons the justices do things and the excuses that they give for doing them. And that is what's really motivating the court and what do they write in their opinions so that it will look like law. And I don't mean to be disparaging about that. The court has enormous responsibility socially for us. They have to make the country, help make the country work. The rest of the government is kind of broken. And if the court is interpreting a statute, the idea, we think, okay, the justices do their best, they interpret the law, and if it doesn't, they don't get it right, Congress will come along and fix it. That is not true. Whatever they do is going to stay the law, and so they have to make it really quite functional. And so they have to be relatively pragmatic about it. Part of the difficulty for the justices is that when people say, they don't do this and they don't know how to do this and they don't really know the issues that come with legislation and how things work in the real world, there's something to that, and the justices are aware of it. So what that means for me as an advocate is that when I am thinking about the court, I am conscious of the precedent. I'm extremely conscious of the statutory text. I will say in a statutory case, if the text says that something is the rule, the court will do that. But so many cases get to the Supreme Court in the first place because the case falls into the interstices in the law. The lower courts have divided, and so that generally means that there is some significant ambiguity to be resolved. And so the justices then have enormous freedom to maneuver because the statutory text or the constitutional text in history or the precedent can be read in a variety of different ways. In addition, the justices, unlike your district court judges and your court of appeal judges, on some level can make the precedent say whatever they want to say. If they're forced to overrule it, which sometimes happens, they can do it. But lots of times they're able to say, well, no, that case was decided in 1967. The plaintiff's name was Joe. This is a case named with a party named Sue. It's completely different, obviously. And so they really can, without actually overruling a case, make the law what they think it needs to be. So a huge amount of my practice is actually thinking about what the justices will perceive as the correct, the normatively right and workable rule. Whereas when I practice in lower courts, I'm much, much, much more concerned about what does the precedent say, what is compelled by existing law. Legal practice in front of the Supreme Court is as much an exercise in policy as is an exercise in law. And people need to realize that Supreme Court decision-making is more of an exercise in policy than it is an exercise of law as a result and by the nature of the cases that come to them. Bill?
To follow up on that, if the judges are acting on the basis of their policy inclination, how do you answer the question that I get from my students all the time? They're going to do what they're going to do. So what role does the Supreme Court play?
Have you seen The Advocates? So I would distinguish, first of all, the idea that they are doing it as a matter of policy from the idea that they're implementing their policy preferences. I do think there is a material difference there, and that is, I don't think the justices decide the cases because they want, that's what they think the law should be. It's just that they are very aware of the policy implications of what they're doing. And also, I think it's fair to say that the justices start from a different set of a kind of different foundations in what they think is right or wrong and what good and bad outcomes are, and good and bad roles for the judiciary are. So what difference can you make? Well, lots of these cases involve competing preferences. A lot of law comes out where you start and go in. A lot of it is kind of how you look at the problem in the first place. And so there's a lot in Supreme Court oral advocacy, in Supreme Court advocacy and brief writing in general, and Supreme Court amicus briefs, in trying to figure out, well, if we come at the case from a certain angle. So to take the simplest example, the federal government may do something and it may be preemptive. Well, that immediately implicates two different sets of concerns. One is, what's the substantive law and what should it be like? And the second is the axis between the federal government and the state governments. And so conservatives may be concerned about federalism in that instance, or, for example, the powers of the police. And so you have to kind of be very aware of that. The other thing is that the justices are not a block. The best example probably was the late Justice Scalia. So, for example, later in his time at the court, he, on questions of substantive Fourth Amendment law, came to believe that the government was just taking advantage of too much, and it was kind of running wild with the court's narrow substantive view of the Fourth Amendment, and came to find more and more things were a Fourth Amendment violation. Now, what does that mean in the end? Potentially not very much, because there is now a majority of the court for getting rid of the exclusionary rule. And so when you are arguing a case about those sorts of issues, you may refocus your interests on whether you say this is just a substantive Fourth Amendment case or instead an exclusionary rule case. But I would say the influence that we have as lawyers in the court may well come most from our agenda setting role. And that is, we often think about the lawyers for the cases that they're briefing or arguing at the court, but most of our time is spent trying to convince the court to step into cases or not step into cases. And so how persuasive we are in finding particular reasons to deny review of a case that otherwise would be granted. But that role that we play is becoming less and less significant very, very quickly, because the court was, for a time, staying away from a huge number, a relatively high number of the cases with the highest ideological valence when you were in areas where you weren't entirely sure what Justice Kennedy and before Justice Kennedy, Sandra Day O'Connor would do. Now, with them gone, with Brett Kavanaugh being a more solid conservative, and just in general, conservatives' distaste for Justice Kennedy, that he could blow hot and cold from year to year, having now passed by, conservatives are both much more confident in bringing cases to the Supreme Court, starting them and getting them up, and the conservative members of the court are going to be increasingly confident in granting review because they're not worried, what will Tony do in this case, and could we end up making bad law? So I think that that will be a significant a shift in the court. Now I will say that there is still one other limiting agent, and it implicates the court packing discussion, and that is, we think of court packing under FDR as the switch in time that saved 9. There's this sense that Justice Roberts responded to FDR proposing and introducing the statute into the Congress, switched his vote. And so even though the court packing plan wasn't enacted, it became the case that in the 1930s, by 1937, 1938, 1939, that the New Deal was upheld and the Supreme Court changed direction. Historically, that's probably wrong because those votes were taken even before the plan was introduced. But the modern application of this is that our Chief Justice, John Roberts, is deeply concerned with the public perception of the court and its legitimacy. And a real criticism of court packing is that it would delegitimize the court, but the Chief Justice is concerned that the court not be perceived as a deeply partisan institution and therefore have less respect and play a less significant role in terms of being an institution that's regarded as not just trying to achieve its partisan ends. And so the mere idea of court packing is probably something that causes the court to kind of step back, particularly the Chief Justice, and be less aggressive. It's also in his nature, I think, to do things incrementally. So you will see, rather than where the late Justice Scalia wanted to move quickly and overrule a series of decisions in one case, the Chief Justice is much more inclined to do that over the series of 3 cases in 7 years. The pace is going to pick up, and because we were kind of at an actuarial fraction point where all the older and wiser justices are on the left, this was the left's last chance to stop the Supreme Court from being solidly conservative for a quarter century, barring some entirely unexpected event. And so because conservatives now are quite confident that they have that institution ideologically aligned for a long time, I think the lawyers will play less and less of a role in the cases that people really care about. We should also not lose sight of the fact that the great majority of the Supreme Court's docket is a bunch of dull cases. I won yesterday a case that is unbelievably significant for those who are deeply concerned about injuries to sailors aboard Navy ships in the mid-1960s who worked on boilers and were affected by asbestos that was not put on by the manufacturer of the boiler, but instead by the Navy in later years. That's kind of the workaday docket of the Supreme Court. So I am a hero to those people, let me tell you. And there I had a huge influence. But in things like whether or not we overrule Roe, if I were in that case, I would be a potted plant. It wouldn't matter what I said.
Thank you for this. It's super interesting. beginning of your remarks talking about how it's appropriate that the Supreme Court kind of reflect the politics of the country, sort of how that intersects in your mind with voting rights, gerrymandering, the kind of things that we're seeing on both sides, really, about how whether or not the Supreme Court does kind of actually follow the winds of our national political belief system.
Well, I think it depends. So this is the question of kind of where the Supreme Court sits and sometimes affects our democracy if the theory of kind of the Constitution is that the court will reflect the democracy because of who gets elected president and who takes the majority in the Senate. So sometimes, very rarely, the Supreme Court leads. I think you would say on same-sex marriage, for example, that Justice Kennedy led the charge there and moved the country faster on that social issue than I had seen on any other. Now, there was already a movement, but it really, really, I think, legitimized it in the minds of a lot of kind of people in the country that weren't sensitive to LGBTQ issues. On the other hand, the court does tend to follow along with society and not get too far out in front of it. You know, the civil rights cases it's leading, and in other cases it's kind of in the middle. Part of the problem is that in two areas of the law, the court's own doctrine is interfering with democracy in very significant ways. The most obvious example is partisan gerrymandering. So we have a huge problem where legislators are now picking their voters instead of voters picking their legislators. This is absolutely the case on both the left and the right. There's a case for Maryland right now where the Democratic legislature gerrymandered, and there are other cases where Republicans have, because our computers are super good now. They can find you something unbelievable on Amazon or guaranteed your election to the Texas House of Representatives. Either one, because we know very, very granularly who lives in each house and we can draw lines around it. And so this problem had gotten very bad. Justice Kennedy about 10 years ago had said, I think there could be a problem with partisan gerrymandering, come back, think about what the test would be. I'm just not ready to decide what the exact rule is. And so political scientists and lawyers worked on this for a long time and came back last term, and Justice Kennedy said, I don't know. The court ended up dismissing two cases without resolving them. And now, with Justice Kennedy gone and Justice Kavanaugh on the court, it's quite likely that the court is going to say that it is just not in the judicial role. It is a very, very hard question, to be fair. How much politics is too much politics in politics? And at what point does that cross a constitutional line? But the difficulty is, as legislatures are able to kind of cement their own power, then you don't have the country's politics, the political power reflecting its politics. So, you know, the obvious reason for that is that things are decided, as we were discussing before with respect to court packing, in primaries. If you know this is going to be a Democratic district, you are going to have an extremely a representative from the left, because those are the people, they motivate the base of the party to come out and vote in primaries. And so that person gets selected in the primary, and then who cares what happens in the general election? We know that there are more Democrats. And so you get people very much on the left and you get people very much on the right who cannot talk to each other to save their lives. And that is true in state legislatures, it is true in the US Congress. It is a disaster. It is a really serious problem. And the Supreme Court is going to say, I think, that the courts can't really do anything about it. And the second area that is just an illustration of the collateral consequences of this doctrine involves unions. So the Supreme Court this past term overruled a case called Abood, which had held that public employee unions can charge agency fees to objectors. So this is people, I don't want to be in the teachers' union. The Supreme Court had said, well, then you can't be required to pay for the union's advertising and proselytizing, but you can be required to pay for the union's actual negotiations, because otherwise we have a real free rider problem. That if you don't have that rule, nobody will pay union dues. Why would you? If it can be free, then the union will be required to represent you, but will not have any actual paying supporters. And so the Supreme Court in this past term held that, overruled Abood and said that the unions cannot do that. And there are real follow-on consequences in democratic politics for defunding on some level public employee unions, because public employee unions are very strong supporters of the Democratic Party. And so that's just another example where doctrine can actually have a real political consequence, cycling back into the membership of the courts. So I do think there are areas where it's a real problem and the system is broken, but in general, it's the case that the system is by and large working.
Thank you all so much for being here, and let's thank Gump.